work accesses the computer, it will be treated as contravention. Remedy granted is in terms of compensation. So obviously protecting privacy. Somebody who is illegally accessing my electronic device or possibly a computer or a telephone, it's breach of privacy in general sense, right? That can be challenged under 43A, small a that is. Another provision which turns a civil wrong into a criminal wrong in terms of Information Technology Act is Section 66. Why so? Section 66 expressly mentions this, that if any person commits any act under Section 43 with guilty intention, that is with mens rea, it will be treated as an offence, punishable with 2 years and 3 lakh rupees of fine. That is also a provision which is rather a criminal provision for a wrong which we discuss under 43A. That is also imbibed into it. Before that, there is something which is very, very specific about data protection which has been added into the Information Technology Act in the year 2008. Amendment was done in the year 2008, which was operative since 27th of October 2009. 43 capital A. Now after all the small provisions of 43 A, B, C, D till J, they are done, there is one addition of data protection provision under 43 capital A. Now what is that provision? Well, that provision is somewhat like this, that any body corporate which handles or transmits any personal sensitive data or information, of any individual, discloses that particular sensitive data to another person, discloses that particular personal sensitive data or information to another person, and by that causes injury to that person, is responsible to pay compensation. What does this exactly mean? It's basically any particular body corporate, a company which handles any personal sensitive data of an individual. It's something like password of your bank account, password of your email account, even your mobile number. If that is being shared by a body corporate, a company, to somebody else, it will be treated as a contravention, and in that case you are due for compensation. This is very much there in line with that. This is something which we follow for last few years. Now the challenge is that how do we read that 43A in line with privacy? It is basically a privacy. If I say Airtel gives my number, makes it public to people at large and say that this is the number which you can use, then definitely there is a challenge as to it, right? Definitely data has been shared, and what they said, what is personal sensitive data? Within the same section 43 capital A, they have made a provision which makes it very clear, any password, any number, any identification is a personal sensitive data. So no doubt, if it is shared without my permission, it is breach of privacy. So understand this, that we may not have necessary implications for private breach of privacy in Telegraph Act, but we read it, we see it in the context of Information Technology Act. Always remember this. Another factor, another provision which comes to light, that is through Information Technology Act once again, we have 66E, 66 capital E, which talks about physical privacy of the person. I hope you are all aware of this. Capturing images of body and bodily parts without permission is made an offence under Information Technology Act under 66E. It might have happened, it's a common phenomena. Recently we had a controversy in public places, especially in malls, and Fab India issue, when Smriti Irani, Home Minister of India, she figured it out that there is a camera placed, CCTV camera has been installed in changing rooms, right? Capturing images of bodily parts of the person directly involved with this. They said physical attribute getting captured on mobile phone or even a camera without permission of the person is a crime. Information Technology Act gives a head note under section 66E, which is breach of privacy and confidentiality. And under this nomenclature, breach of privacy, they have included this, physical privacy of the person. So that is also getting covered under Information Technology Act 66E. One last factor which is very much clear in terms of how sensitive we can be towards privacy through Information Technology Act comes in through section 72 as well. 72 of Information Technology Act mentions it clearly that if there is any person who, in pursuance of the powers of Information Technology Act, I hope we have discussed that part also under Information Technology Act, there can be a person who issues you a digital signature. Those are known as certifying authorities in India. If you want to use a digital signature, you have to apply for it to certifying authorities. Who are certifying authorities? They are licensed authorities of Government of India. Controller of certifying authorities gives license to them, and those licensed authorities can only sell digital signatures to you. The controller has the power to look into private keys and public keys of digital signatures. So do certifying authorities. Maybe even for section 43, we have that adjudicating officer who decides the disputes regarding digital signatures, and even section 43. Even that authority might have certain evidences, or possibly in a span of inquiry or litigation, there may be certain disclosures to adjudicating officer, or even for that matter another tribunal which is known as Cyber Appellate Tribunal within the purview of the Act. If such authorities within the power of the Act, within the provisions of the Act, have the power to have a recourse to that particular data, and they disclose this to somebody else, it will be treated as an offense. Now you imagine this, that what is happening with the privacy, especially under 72. If any legally established competent authority, if that authority breaches privacy by disclosure, that itself is made a crime now. So they are not looking only in terms of general security or general safety of data or general disturbance of privacy, but now they are also behind the legal enforcement agencies. I hope this gives you an exact idea as to how we need to look forward to the privacy in the line of all these legislations. The takeaway from this session is that yes, we do have a law on privacy even before Constitution. We had that situation because of Telegraph Act 1885. We have certain provisions in Telegraph Act which may challenge the whole set of situation. Only public emergency and public safety are the grounds where surveillance is possible. It's been reiterated again and again in different form of judgments, right from Kharak Singh to Amar Singh, Dono Singh. This Singh to that Singh, we have a singing provision of Telegraph Act, section 5, being enforced together with little bit of reasonability towards privacy of the person. So telephones can be used as a mode of interception, legally valid only if it is done reasonably with proper involvement of law. Thirdly, we do respect privacy of the person if it is breaching the privacy within the scope of Article 21. But Article 21 has to be read in context of procedure established by law. So what government does or any investigating agency does is procedure established by law, which is enforced through rules under Telegraph Act, are followed. And if government or fundamental rights is not at all in question, a private party is breaching your privacy through telephone surveillance or possibly through technical means, it can be challenged under Information Technology Act. 43 small a, 43 capital A, 66, 72, 72A. These are the provisions which come in line with that.